Hi, I'm Tom Eschen, and this is Power and Politics, the conversation about the issues that are impacting you the most in the Capital Region, in New York, and beyond that with the people, the advocates, the officials, everyone in between that are making decisions and are also calling for change. Today we focus in on the New York State budget, and one of the biggest issues of the budget this year is the discovery laws. Passed in 2019, now they're looking to change some of those laws at that. So we speak with Albany County District Attorney Lee Kindlon about it. He's been in Governor Hochul's office talking to her about this exact issue. So he breaks down some of the language they're focusing on right now. This is important because it impacts victims, those that are accused, and also everyone that's involved in this process in the judicial system. That includes judges and also law enforcement too. We get into all of that over the course of the next 30 minutes. We hope you enjoy it. The Albany County District Attorney Lee Kindlon joins us now for a deep dive into discovery. Lee, thanks so much for doing this with us today.
Yeah, my pleasure.
So let's start with where you have been over the course of the past few weeks and months, something that we've spoken about after this was initially proposed by the governor back in January. But you were pictured in her office, I guess, and at the table, the round table last week. Why have you been involved in these conversations regarding discovery?
Because I think I have a unique voice to bring to the discussion. Obviously, the first 18 years of my professional career in Albany, I spent as a hard-charging, fire-breathing defense attorney, which gives me a certain perspective. And now I'm the district attorney in Albany County in charge of making sure that all of the discovery gets from law enforcement, various investigating agencies, to the defendants and their attorneys. So I want to make sure that my voice is heard at the table during the discussions, and so everybody gets a full picture of what's going on.
Why do you think changes are needed to the 2019 reforms that were put in place?
So the 2019 reforms were great because we talk about the bad old days when, as an attorney, you didn't get any important materials until almost the eve of trial. And I wrote an op-ed for the Times-Union back in February where I talked about a case in which I didn't get an important piece of proof turned over until a few days before the trial was supposed to go. And I don't want to go back there. Nobody wants to go back that way. But any law passed is going to have some unintended consequences, and that's what legislation is for maybe now, to clean up some of those unintended consequences of the reforms that were passed 5 years ago. So the most common example I cite is the growth of this cottage industry of discovery compliance motions that can be hundreds of pages long. And it's all whether or not the district attorney's office has turned over the body camera footage from the fifth cop to appear on scene. And if we haven't turned it over, if we haven't turned over anything related to, it's a very broad scope, anything related to the case, then we risk dismissal. And that's a really harsh punishment when it comes to the prosecution, especially when sometimes failing to turn over a piece of paper, it might not be relevant to the case at hand. And so what we're trying to do is draw down the turnover to what's relevant to a case, because why turn over irrelevant material, but stuff that's relevant to the prosecution. But also build into the legislation now instead of just dismissal, build in this idea that there's a more pragmatic solution. Maybe the defense gets an adjournment when stuff gets turned over late. Maybe there can be preclusion of discovery if it's turned over late. Dismissal's always on the table still as potential remedy, but we just want to make sure that there's some sort of proportional response to perhaps late disclosure. So those ideas have been part of the discussion from day one.
Is that the nature of someone taking advantage of loopholes in this? Well, everything you just spoke about, is that what is happening now on the prosecution side, on the defense side? Is that what is the cause of some of these dismissals that we're seeing mainly in New York City?
Sure, and again, that's what a defense attorney is there for, is you're supposed to find a way to use the law to benefit your client. Right. So if defense counsel can write a motion to get their client's case dismissed, of course they're going to try and do that. I mean, that's goal number one. Goal number two, and this is something I've been very, open and honest about, is sometimes a point of litigation. And that's the problem we're seeing, especially upstate, is to slow our criminal justice system to a halt. Because, look, my prosecutors have to watch every minute of body camera footage, which can be hours and hours of one of my ADAs sitting in front of a computer screen watching body camera footage from every cop out there. And then we've got to organize, catalog, and turn over all of that discovery. And again, I've invested millions of dollars in time, in personnel, in resources to making sure that that happens. But it still has to happen. And then we have to go through the hours of litigation to respond to giant stacks of papers, motions to dismiss and motions, supplementary motions on discovery compliance, so it becomes this time suck. And sometimes that's at the point, because if you can slow down the criminal justice system enough, maybe you can discourage the victim from continuing to come forward. Maybe the cop retires. I mean, the more time you build in as a defense attorney between the day your client's arraigned and the final day of the case, that is a way to sometimes benefit your client. So what I'm saying as a litigator is, let's figure out a way to get from the day a case starts to the day that the case can be adjudicated on the merits, because that's what everybody wants. Nobody wants cases dismissed on technicalities. Everybody wants to seek justice, not just for the defendants involved, but also for the victims, for the people who choose to come forward, for the people who keep coming to court to see that that their voice as a victim is heard. That's one of my main concerns right now.
And when it comes to these negotiations, these talks, and I know it's a very fluid situation, what is there at this point, and if you can sum it up, you mentioned some of the things that have been discussed, the relevance versus related to charges, right? How big is that of a priority for you when it comes to making sure that's changed to relevant instead of related to?
Well, obviously my goal is to make sure that my prosecutors have as many tools in the toolbox as they can to make sure a case gets from, again, like I said, the day a case is charged to the day a case is resolved on the merits. So what the exact, mix is, that's politics, and that's for them to figure out. I just want to make sure that the voices of upstate DAs are heard and listened to, and it's been very rewarding so far.
Has the getting rid of the 30-30 dismissal on the table at all? If I'm saying that right?
You are saying that right.
The speedy trial,
the
right?
speedy trial, and talks about
taking that off the statute.
So-called decoupling.
Yeah.
That's always been part of the discussion. But I think what I think is more pragmatic solution, and what's been discussed more, is less severe sanctions on the prosecution. Like I said, not just dismissal, but given the amount of harm through the defense's case, what other solutions are out there, like adjournments, preclusion of testimony, some other things that a defendant might be able to take advantage of.
So 2019 reforms, I think a lot of the people that were pushing for them and still are today saying it leveled the playing field when it came to this. Sure. Do you think it did that, or did it obviously, you believe it went too far?
Now, honestly, from this vantage point, I can see how maybe it did go too far, and so that's what that's why we have a government. If a law is passed and it didn't work perfectly, and it's taken us a couple of years to see maybe some unintended consequences, now we can sit back and say, okay, it was a great step forward, but every law, everything we do sometimes needs a couple tweaks here and there.
Can some of those other options, other than dismissal, be taken advantage of? I just say that from the standpoint of there is the concern that an individual and those that are for justice reform might say, this is going to cause more people to stay in jail and have their trial go on longer, months, years, because the prosecution isn't being as forthcoming as they should be.
Sure. Look, I understand that there's always these, what ifs, these speculative harms that occur out there, and dismissal is, as I understand, is always going to be on the table as a remedy for the courts. So there's always going to be the ultimate sanction that can be leveled against a DA's office if they don't turn over materials. But I can tell you, we're not going backwards. I'm not sitting around trying to think of ways to, let's not disclose things to the defense.
You did tell me that you did take advantage of some of these things as a defense attorney, right?
Oh, sure.
You did say that in the past.
Yeah, in that interview we had on
the
South
street.
Pearl.
Yeah, on the street, yeah.
Sure, but because that's what a defense attorney does. The only concern you have as a defense attorney is for your client in this case, which that's the job. My job now is different. My job now is to worry about the entire criminal justice system and making sure it works well for everybody involved. And yeah, I still have a deep-seated concern for how a defendant's case is going. I want to make sure that they have access to everything that they need, right? But now my purview is just bigger and it's different. So I am now charged with worrying about victims, worrying about the men and women of law enforcement, and making sure that their jobs, all their hard work is rewarded. Because they're sinking their time, their energy, their passion, all these things into their job. So I got to make sure that I can look at them in the eye and say, all the hard work you did paid off.
The caucus, as you heard mentioned in there a couple times just a few minutes ago, they have been pushing to codify People versus Bay, which would mean the prosecutor is that rule that if a prosecutor is operating in good faith, doing due diligence, everything's okay. Where does that fit in this conversation for you, codifying that ruling?
People v. Bay, read a bunch of times. It's a great tool for all of us to have as litigators. But I think, again, just thinking about pragmatic tools to try and get a case to its conclusion, I want to make sure that there are other remedies other than dismissal. And, if Bay ultimately ends up as part of the legislation, which, again, I only know, I know is out there, I think that's, a solution. But I certainly think that there have to be some other things out there, again, that we can use.
You'd be okay if that was included alongside the other protections for your office?
I mean, look, People v. Bay was decided unanimously by the Court of Appeals, so that's the law. That's what we're all doing anyway. But with Bay being in the background, the DA's Association got together and said, we need other things that we can use to make sure that we can do our jobs. So, I don't think People v. Bay is the end result. Otherwise, we wouldn't be having this discussion about things that we need to do to fix discovery.
People v. Bay, a part of that, I think some would argue, clarifies things a bit. Sure. Not only for the prosecution and the defense, but for the judges as well.
Right.
And I've had conversations with some upstate lawmakers about some of the judges aren't necessarily, I don't want to say qualified, but they're not as read up on case law, or they're not, they don't go through the minutia of some of this, and that could help. Do you think there are things that need to be done to help judges better understand what needs to be done in cases like this? Because that's what I'm hearing is part of the issue outside of New York City when it comes to this. Because you referenced it in there that you have smaller courts that aren't as resourced, that don't have as many people working, that can't necessarily even have the data, right, to discuss dismissal of cases, or to be able to track that. So I guess I'm wondering, is clarifying language a part of this too, to help those smaller courts be able to handle some of this when it comes to the prosecution?
Yeah, look, I read People v. Bay a couple of times because I had to read People v. Bay a couple of times to understand it. I mean, the Court of Appeals judges are, the most brilliant jurists in the state, and town and village courts are unique in New York in that you don't have to be an attorney to be a judge. So you take hardworking men and women from the community who are committed to their community, and they run for judge, and they deal with these heady, complicated legal issues. I think sometimes having clarifying statutes that lay down very clear rules it would be helpful. And why not have more clarity? And why not, instead of just saying there's this Court of Appeals decision, go read it. Why not have it in black letter law written in a book? Again, I think that's the most realistic solution.
Even if it's not that, what do those courts need to help with this issue when it comes to discovery, when it comes to pretrial and all that?
Well, look, OCA does a great job in how they train judges out there. Training, education, experience, what the rest of us need to do our jobs well. So, and people can always act as a resource, and sometimes that's the point of litigation. What I've seen now, though, is, the point of litigation is not to get to the merits of a case. The point of litigation is to slow the whole thing down.
Why was the funding over the course of the last few years put towards discovery not enough? The millions of dollars that the prosecutors were given, why hasn't that gone far enough?
So there's a startup cost to anything. And so a lot of it was, how do we build the system from scratch? Because again, let's talk about the bad old days. It would be like the Wednesday before trial, and some prosecutor, following the rules at the time, would hand me a stack of papers, here, and it was disorganized, and it was upside down, and it was badly photocopied, and in one county, they'd hand you that stuff right before opening statements. So you're like flipping through grand jury testimony, trying to figure out what the complaining witness said as the prosecutor's giving his or her opening statement.
That's nuts.
Yeah, but that was standard practice because those were the rules. Now, I mean, look, everybody's got a Ring doorbell. Everybody's got security camera footage. Every cop's got a body camera. Most of the documents we have are electronically stored. So everything is computerized. Everything's digitized. And everything needs to be turned over. DNA reports can be 1,000 pages long. And we've got to sit there. We can't just give them 1,000 pages. We got to go through it all because as attorneys, we've got to certify that we've looked at everything. Yeah. Hey, Judge, I've looked at everything. I signed my name to it. Here, I turned over everything that we have. So it's not just the old days where here's a couple of sheets of paper, let's go to trial. It's, like I said, here's 18 hours of body camera footage that I've watched. That's time, that's people, that's money, that's things that it was great that we got that money to invest and build the systems from scratch, but now those systems need to be maintained. Like, computer storage costs money. My discovery clerks are people who have salaries, and I've got to pay for them, and they work really hard to get all those things done. So it's not just a one-time cash infusion, haha, problem solved. No, now it's an ongoing thing to make sure that we're, fulfilling the spirit and the letter of the law. Yeah,
the implementation of body cameras for sure, I'm sure has been a whole different element of this. And that's definitely something that's come on over the course of the last, you could say, decade, you could say. It's been implemented on more and more police units.
Yeah, and juries love them. Yeah. Because it's like you're watching the incident unfold in front of you. And so now, if a case doesn't have body camera, everybody's looking around saying, well, why not? And just so to put all of these things together is necessary, especially if you're going to present a case to a jury. We've got to pay for it. And that money was great, and it's always appreciated, and we're going to spend it, but we got to keep going.
The other element here, law enforcement, which is a part of the body camera, but also any other evidence, things of that nature. What role do they play here, and do they need to do better when it comes to this in terms of turning some of this over to the prosecution and the district attorney's offices?
So, law enforcement's doing a great job, and I know this now because I've been with them, I've worked with them. They're hardworking men and women in law enforcement all over Albany County in the state. We have almost unfettered access to everything that the police department has. So, but in Albany County, I'm dealing with more than a dozen police agencies. Green Island, the Sheriff's Department, the Albany Police Department, Kindlon, the Albany County Sheriff, the state troopers. And so we've got to corral all those resources and get everything together. And on any given criminal case, there's usually more than one investigating agency, between the state police labs and the Albany Police Department. And so, they're doing everything they can. Even though a lot of agencies are down on manpower, they're putting in the work to get these things done. And it's always been my responsibility, and I said this to the Albany Police Department this morning, you treat us as force multipliers. Like, as hard as they work, I want to make sure that we are there to help them do their job easier, better, and make sure that their investigations are closed and prosecuted.
I know it's more of an issue with the NYPD and down there in the city when it comes to turning this over. Should there be something, though, on the books that incentivizes them to turn information over quicker?
Yeah.
Or is it just right now? I mean, I totally get it. Albany right now, we know how understaffed their police department is. And we know that they're dealing with shortages. So I think that's one element. But if we're looking at a statewide issue, I guess I'm just wondering if there should be something on the books that does incentivize that. It almost not like People versus Bay, which makes it a little more clear, but also says if they are trying to turn information over and doing their due diligence, then that's okay.
So, and I know that bill that's bumping around in for the New York City police departments and their direct contact with the district attorney's office. There are issues in there because really, like, the DA's office is dealing with one police department, and who has access to police department records. That's its whole separate animal. That truth be told, I don't know enough about that bill and how, like, the city DAs and those city police departments are working out their discovery exchange. So I just know that it's never really been discussed as an upstate thing because, again, I've got so many different agencies. It's not just a, connect tab A into slot B and you're done kind of solution. We're dealing with so many different entities here.
Okay. So. I do have another thought, and that's about, obviously you've been very active in this, and this is a big part of what you've in your new role here since January, which I'm sure has been interesting considering now the spotlight's been on discovery. But as you were running, we talked a lot about criminal justice reform, talked about bail. We also talked about raise the age, and I remember in our conversations, debate, discovery didn't come up, raise the age did. So why do this for discovery and not raise the age? Why not be in the Capitol advocating for changes to that law?
The District Attorneys Association and the DAs around the state decided that this was the issue this year. And, I'm want to make sure that Albany County, because of our central location, obviously, the Capitol's in my jurisdiction, I want to make sure that our voice is heard. I want to make sure that my voice is heard. So if tomorrow they called and said, hey, Lee, we want you to talk about raise the age, I'd say, great. When and where? But right now the discussion is about discovery. And, look, I know there are efforts to change raise the age and efforts to work on bail reform, but right now this is our primary push.
Because I asked because raise the age is something we've heard on both sides of the aisle that people have seen issues with when it comes to resourcing and implementation. It feels like that has taken a big back seat here, and it's something that has been on everyone's minds, and now discovery is sort of taking up all the air in the room.
Yeah. And look, I have problems with raise the age. I've said it a bunch of times. It's just an incomplete law. It's like a building with no interior structure, and it's frustrating. Sometimes, there's some unintended consequences from that. I mean, I've said it a bunch. I think incarcerating, youth is just barbaric, but the resources haven't been given to raise the age, and I've seen it, and it's frustrating being a prosecutor and trying to deal with some of these issues. I can tell you we're finding as many courtroom solutions as we can to fix the problem, but it's my hope that in the near future we can go back up the hill and address raise the age, because there are solutions out there, and I think everybody knows what they are. But we've got to have a good, honest, earnest conversation about where we go with that.
Have you had? When was it? Have you been in the Capitol before? Like, and is this? I guess how new is this for you to be out there and stumping for something like that? I mean, obviously you were defending for a long time.
Yeah.
For you to be up there with the governor, and in one of her posts on social media, sitting on a couch, I guess is that something you had done before?
No. This is like I grew up in Albany and I went to the Capitol on field trips and stuff. It is a new role. I'm happy to do it.
Yeah.
Again, I think it's important to have my voice heard because I bring a unique perspective to all these things. But sometimes I wake up and I think I'm just a lawyer running a law office. But then I realized that there are all these other responsibilities almost unique to the Albany County DA's office. And, I've had a lot of really good conversations with the governor. I'm really happy for her advocacy on something like this. I mean, she really is standing firm on getting this done, so I really appreciate that. No, I go up to the Capitol, I still need people to direct me where to go because I get lost.
So do I, yeah. How does that conversation go? Does she call you?
Yeah, well.
It's like, hey, welcome to the role. Can you come up to the Capitol to help me with this?
No, her people call my people and I run right up. So, it's a good relationship and again, I'm happy to do it, so.
Lee, thank you very much. Appreciate
no
the
worries,
time.
Tom.
Thanks.
Of course.
Thanks for listening. Hit the subscribe button right now so you can stay up to date on these news-making conversations about the issues impacting New Yorkers the most: power and politics.